Okay, my clock says that it is now 2:01, so I'm going to begin recording this lecture for next week's presentation. Today's lecture is going to be on competency, and that because that's what next week's presentations are. The question that the panelists, four, the four people, the two in Tuesday's class and the two in Thursday's or Monday's class and Friday's class, four people are going to have to answer is, was John DuPont competent to stand trial? But before we talk about that question, there's a couple of things that I want to go over with you in terms of um, in terms of the legal process and the legal state. The legal process in our country is founded on the concept of personal responsibility. And in order for somebody to be personally responsible, they have to be aware of their actions. Now, we talked about mens rea in previous classes in terms of mens rea refers to the person's mental state at the time of the crime. But mens rea also refers to an individual's mental state at various different parts of the criminal process. In the criminal process, an individual is charged with a crime, and then they have the right to defend themselves. And this becomes incredibly important here right now, is our system of laws and government, at least as they are right now, basically states that anyone charged with a crime, or in the case of civil matters, anyone who is accused of a tort, that is, anyone who is accused of violating their responsibilities to others, has the right to defend themselves. They have the right to present evidence. They have the right to examine the evidence of the other side. They have the right to in essence, prove their innocence. Uh, Now, in order for somebody to be able to do that, they must be what's called competent. There are a number of different competencies in the justice system. We have criminal competencies, which we're going to talk about, as well as civil competencies. And a lot of people get these things wrong, get these things very wrong. Uh, a criminal competency simply refers to whether or not an individual has the mental capacity to uh, to be able to respond to the charges against him or her. If somebody is brain dead, okay, for example, their body is still alive, they're still going, they're still technically alive, but their brain is no longer functioning and they're in a vegetative state, we would all agree that that person is not capable of being of responding to any sort of criminal charge brought against them. So if I go out and I shoot a bunch of people, and this is not an unusual situation, and I myself am shot, and by the police or by somebody else, and as a result of being shot myself, I become brain dead, or I go into a vegetative state. I am in a coma. Charges cannot be brought against me because I am not at that point in time capable of responding to those charges. And so I cannot be tried, I cannot be convicted, I cannot be sentenced. And those are the different parts of the legal process. Let me bring up my whiteboard here to kind of talk about this for just a minute. The various parts of the criminal process are: once somebody has done something or has failed to do something that they are legally mandated to do, an act of omission, that is, they didn't do something, or an act of commission, they did do something, there are then charges brought against them. An individual is charged with a crime. The district attorney In our system of laws, the district attorney is the only one who is capable of charging someone with a crime. The police gather the evidence, the police make the arrest, the police gather the evidence, but the police turn that over to the district attorney, who decides whether or not the evidence is sufficient to charge an individual with a criminal act. If the district attorney can decide to do what's called a grand jury. A grand jury, in some very severe cases, a grand jury will look at the evidence. A grand jury will make the decision as to whether there is enough evidence to charge the person with a crime. Now, notice that when somebody is charged with a crime, they have not yet been found to be guilty. That is a whole different process. All it means is that they are is that there is evidence, there is substantial evidence to suggest that they have done something wrong. The exact charges brought against an individual is determined by the DA slash grand jury. And then that starts the criminal process. The DA, by the way, can choose not to charge someone with a crime, but that does not mean that later on they then can't charge them. So the DA may say, we don't have enough evidence now, but then 6 months, 8 months, a year later, they get more evidence. They can then reopen the case and decide to charge the person at that later date. This is not that double jeopardy that you've heard about, and we'll talk about that double jeopardy. If not today, we'll certainly talk about that in a future class. But the idea is that the individual is charged with a crime. Once the individual is charged with a crime, the individual then has the right to file different motions. There is the motion for discovery, for example. If you have been charged with a crime, then you have the right to see all of the information, to see everything that the other side has against you. There are no Perry Mason, and many of you probably don't have a clue who Perry Mason is, but there are no Perry Mason scenes in court where a surprise witness appears at the last minute. That doesn't happen. That can't happen. Uh, once a trial begins, the evidence you have is the evidence you have, and you can call a mistrial and go back to square one, but you can't present surprise evidence. The discovery, anything that is not presented during this discovery phase cannot be used. So an attorney calls me up and says, Dr. Keppel, I want you to evaluate my client for whatever issue. I then evaluate the client and I give that to the attorney. If the attorney decides not to use that information, that then is not discoverable. But if the attorney decides that he or she wants to use that information then becomes discoverable, and they must release it to the other side or they cannot use it. Everything in a court case is open. We don't have secret courts in this country, at least not yet. There are some people who would love for us to have secret courts, but at this point in time, we do not have secret courts. Everything is open and available. So the discovery. There can be a motion to dismiss. A motion to dismiss means that I can sufficiently refute the evidence that the charges against me should be dropped. And you'll often hear about the DA dropping charges. You'll often hear about the court dropping charges. That's in these motions to dismiss. Information is presented that indicates that the data, the investigation report, has sufficient holes in it that the charges are no longer valid and should be dropped. Now, it doesn't mean that at a future time you cannot be recharged with the crime, but it does mean that at a future date, in order to be recharged, in order for charges to be had again, the the side that brings the charges has to be able to demonstrate that they have new information which is sufficient to overcome the objections that were raised during the phase of the various motions. Uh, you then have plea, where the individual, and my finger is not working well, the plea, where the individual then pleads, and we talked about this in class. I believe in the Friday class, we talked about the various different pleas that an individual can enter. And then you go to the trial, okay? Those are pleas, and then there are other motions that can be entered in. And then there's the trial in which the information is presented and both sides get to argue and get to examine and get to criticize the information in terms of determining what is true and what is not true. This is the basis of our system. Now, as you can see, this system is quite complex. The system is quite complicated. And the question about competencies has to do with the ability, the capacity of the individual who is charged to be able to respond to the charges and to be able to um, and to be able to um, um, defend themselves, basically. The concept of competency permeates all of our legal system. An individual must be competent to enter a contract, otherwise the contract is void. Individuals under the age of 18 are not competent simply by virtue of their age. Until you turn 18, you cannot enter into a legally binding contract, which is why your parents must sign for your driver's license, which is why your parents must sign for any student loan you get if you're under the age of 18. Until you turn 18, you are automatically not competent to enter a contract. A will written by an individual lacking competency is not admitted to probate. An individual must be competent in order to consent to medical treatment, um, and so on and so on. So what is competency? What does it mean to be competent? Well, um, competency means that an individual has sufficient ability to understand what is happening to him or her. This is why a lot of individuals with intellectual deficiencies are determined not to be competent. Um, so there are a number of different competencies, as I mentioned. There are criminal competencies and civil competencies. They all revolve around an individual's ability um, to make decisions for him or herself. So let's talk about the criminal competency and the one that is being proposed for John DuPont. Now, competency is not the same as insanity, and I want to emphasize that. Competency and insanity are two different issues. Competency is that um, one rationale for competencies is due process clause of the Sixth Amendment, which guarantees defendants the right to effective counsel, the right to confront one's accuser, and the right to be able to present evidence. Exercise of these rights requires more than simply the person being physically present. Defendants who are not present mentally cannot help their attorney and cannot effectively respond to the charges against them. That is, put it in another way, in an ideal world, the criminal process would be a trial between evenly matched adversaries. The defendant and the state are evenly matched in terms of their ability to examine the evidence. This process posits that defendants able to participate in their own defense. Without the competency doctrine, the rights afforded by the Sixth Amendment would be empty for many individuals. A second rationale for competency requirement focuses not on the individual's rights, but on society's interests. The defendant must be competent not only to ensure a fair result, but also to guarantee a dignified criminal process. The adversary form of the criminal proceeding necessarily rests on the assumption that the defendant will be a conscious and intelligent participant. The trial of a defendant who cannot fulfill the expectations is inappropriate and irrational. Even a proceeding that produces an accurate guilty verdict would be repugnant, would be unconscionable if the convicted individual were unaware of what was happening or why. So the competency requirement is extremely important. So in looking at John DuPont, the competency issue does not rest on did he do it or didn't he do it. The competency issue doesn't rest on is he legally insane and responsible for what he's done. The competency issue rests upon is he capable of assisting in his own defense. And so there are a number of tests that the courts have developed. And what I mean by tests is there are a number of factors that the individual has to have in order to be determined to be competent. Okay, and I'm going to go over there. There are exactly 21 different things that you have to consider for competency. Let me do this text here. The first question that is important, that are relevant to the competency issue, is the individual's ability to understand his or her current legal situation. And this is rather difficult to do. That is, does the person understand what is currently going on with him or her? Okay. Do they understand that they are being arrested? Do they understand that they are being criminally charged? Do they understand that if they are found guilty, they can go to prison? Do they understand what the potential penalties are? So they understand the current legal situation. Does the individual understand? So I'm going to get rid of this because all these are understanding. Does the individual understand the current legal situation? Does the individual understand the charges against him or her? Do they understand the charges? Does the person understand the facts? Do they understand the facts relevant to the case? Is the individual able to understand the legal issues involved in the case? Is the individual able to understand the legal defense? Okay, to understand the disposition. What I mean by the disposition, that is, what are the possible penalties that can be applied to his or her case? Do they understand the possible penalties involved in the case? Do they understand the likely outcomes? Do they understand the likely outcomes? Do they understand the role of their attorney? Do they understand the role of the judge? Do they understand the role of the jury? Are they able to assist the attorney in their defense? Okay. Are they able to assist in their own defense? Are they able to testify? That is, can they do they have the capacity to explain themselves and to explain their side of the story? Do they have that ability? Um, these are some of the issues that are involved. Now, when you're doing your presentation, when you're evaluating the individuals who are doing their presentations, you don't have to address necessarily each and every one of these um, issues. The basic issues that you need to address in doing competency and in looking at competency are the individual's ability to understand the legal process, the individual's ability to assist their attorney, and the individual's ability to explain themselves. So all of these things can be um, boiled down into those three basic processes. Understanding the legal process, do they understand the role of the judge, the role of the jury? Okay. Do they understand to assist their attorney? Can they help their attorney to find evidence? Can they help their attorney to present their case? Do they have the ability to work with their attorney? And then do they have the ability to explain themselves? Can they describe to a jury, to their attorney, what they did and why? And that why becomes incredibly important. Now, we can take a look at different um, at different aspects of competency. We can take a look at different aspects of competency. One of the aspects of competency is who may raise the issue. Who may raise the issue of whether or not someone is competent. In general, the defense attorney most frequently initiates the competency inquiry. However, in most jurisdictions, a motion for an evaluation or hearing on competency may also be made by the prosecutor or by the judge. So if the judge notices that a defendant doesn't seem to understand. A defendant doesn't seem to be able to assist his or her attorney. A judge can halt the court proceedings and say, we need to make a determination as to whether or not this defendant is competent. When the issue of competency is raised, the legal process stops. If the individual is not competent, it cannot go forward. It cannot move any further. Now, again, this doesn't get the individual off. It doesn't get the individual off. What it means is that simply the court cannot proceed until the individual can be made competent. There is an entire unit at Dorothea Dix Hospital for individuals who have been judged incompetent. They are sent to this unit to be made competent through treatment, medications, through psychotherapy, through educational groups, through different processes. These individuals go through treatments that they can become competent, and when they are now raised to competency, the trial can now go forward. The trial can now go forward um, in that. Um, It must, who may raise the issue? Keep in mind that the issue of competency, competency is a legal issue. It is not a clinical or psychological issue. Now, while we psychologists often are called to make competency evaluations, it is not our decision. The judge reviews our report and makes the decision as to whether or not the individual involved is competent. Um, okay. Now, what I want to do here is I want to back up for a second. So this is the basic issue in competency. Is the person capable of responding to the charges against him or her? That's the basic issue of competency. Now, I want to go back and I want to look at a couple of things, and this is for the people who did their presentation last week or those who are going to do it on Friday, as well as for the people who who are doing their presentation next. Keep in mind that when we are evaluating an individual, we are looking for four sources of information. I've said this before, and I'll say it again here. We're looking for four sources of information, and not in any particular order. We're looking for life history. Okay, we're looking for self-report. We're looking at direct observation of the individual, and we're looking at the reports of others. So these are the four sources of information on which a psychological evaluation is based. Now, oftentimes these things get translated into a psychological test. But as those who have had me for psychological assessment know, a psychological test is simply an objective, standardized measure of a sample of behavior. Okay? So all a psychological test is doing is gathering life history, self-report, direct observation, reports of others in a standardized way, in an objective way, and is then looking at comparing that to other individuals who are in similar situations. That is a psychological test. So when you are looking at these situations, you need to be able to present all four of these points. In a competency evaluation, you are focused more on self-report and direct observation than you are on other types of data, but the other types of data are useful too. So this is kind of a caveat. So going back to this, when you write up your report, whether it be this competency report that I'm presenting to you or not, a psychological report, a psychological evaluation, and those of you who have submitted your reports already, I'm going to send back to you so you can do this right. A psychological report, a psychological evaluation is written in a number of very specific ways. It is the first part of a psychological evaluation is you need to identify the individual. Who is it? Who is it that you are evaluating? This takes a lot of different forms. In general, the person's name, age, a little bit of their little bit about their background, and so on. Then you need to identify the question that is being asked. In other words, so we have this individual. Why are we evaluating them? what is the purpose of the evaluation? And so you then need to identify the question asked. These are typically separate paragraphs and or separate sections in a report. The next thing you need to do is you then need to present your evidence. Okay, this is a legal procedure. We have the who the person is, we have why they're being evaluated, then now you need to present your evidence. And typically we present the evidence as I've shared it with you. Most often we present life history or life events first, person's background, person's history. We then present reports of others about the individual. We then present the individual's self statements, and then we present our observations of the individual. The exact ordering of this is not all that critical, but you must present your evidence. You must present your evidence. Failure to present your evidence means that your evaluation is going to be considered inadequate. The question becomes, how did you arrive at your conclusions? How did you arrive at what you were doing? Then you present your summary where you answer the question. Answer the question. In your summary, you need to indicate the legal issues involved, or I should say the psycho-legal issues involved. And we're not lawyers. We do not address the legal issue. We address the psycho-legal issue. That is, we provide the psychological rationale, the psychological understanding necessary to enable the court to be able to address the legal issue. So we identify the psycho-legal issues involved, and then our conclusion. What do the data tell us about what do the data tell us about the question? Now, when we get back up here to present your evidence, you may understand, well, where does the PCLR go into here? Where does the PCLR fit? Well, the PCLR is based on life history. The PCLR is based on reports of others. The PCLR is based on all of this. And so if you need to, you can include a separate section in your evidence on, rating scales, tests, psychological tests, and other things that are there, but present your evidence. If you're using a rating scale like the VRAG, those of you looking at a violence risk assessment, you may want to use the VRAG, the Violence Risk Assessment Guide. Those of you looking at the PCLR want to present the results of the PCLR. What did you find? And when you report the scores on the PCLR in a psychological test, you need to report why you found those scores and how you came up with that score. Okay? So this is in general the format for a psychological evaluation or a psychological presentation. When you submit your write-up of your client, when you submit your write-up of the case study you are doing, I expect to see this. And I expect to see it in pretty much this format. As I said, the life events and so on, this here can be kind of a little bit different depending upon your client. But this is exactly what you're going to find. Now let's take a look here. I'm going to share with you I'm going to get rid of this and get rid of this for a minute, and I'm going to pull up an evaluation here. And this is, and again, when I pull up these evaluations to share with you, I am not sharing evaluations that are perfect. I'm sharing with you evaluations that are typical. There is no such thing as a perfect evaluation. Okay? Okay. Um, I'm looking for one here. Hold on, I'm looking for one specifically. Okay. I'm going to pause the recording. Recording is restarting now, and I'm going to share with you a competency evaluation that I did. Now, this one that I'm showing you here is very, very long and involved. And what I did was I removed all identifying information on this because I don't want to violate somebody's confidentiality. Certainly don't want to violate the confidentiality of this individual here. But anyways, with this, and let me view it here a little bit differently. Um, there we go. Okay. Again, you don't have to do it. When you do yours, it does not have to be nearly this complex. If you had your PhD in psychology and it wasn't this complex, then I'd think there was something wrong. But this is not a psycho. This you're just learning, so don't do it necessarily this complex. The current evaluation was requested by this woman's attorney to concerning her, and I'm highlighting this, capacity to understand the nature of the charges against her, communicate with her attorney, and assist in her defense of the charges. These are the primary issues in a competency evaluation. These are the primary issues to be addressed. Okay? The issues to be addressed include the possible presence of any mental health diagnosis and the impact such a disorder, if present, on her mental and emotional ability to stand trial. So, in order to be able to render somebody incompetent, there has to be a reason that they're incompetent. In the case of this woman, some sort of mental or emotional disorder. In the case of other individuals, it could be a physical disorder. It could be a number of different problems that would render somebody incompetent. But I'm a psychologist, so I'm looking at um, at the impact of her mental and emotional functioning. I then provide the data. Okay, this is where I obtain the data. These are the sources of my information. And then these are the relevant data. So I have legal records. This is life data here, L data if you want. Medical records, again, L data. Previous psychological evaluations. This is what other people have said about her. Relevant background information, again, more life data here. Behavioral observations. This is my observation of her, my observation of what she is doing here. Interview with her, this is her self-report. Again, all of the data that I'm talking about with you. So the results of the interview with her, these are the things she said to me. Uh, the test results, again, whatever types of data that I have, I'm presenting. This is direct observational data again. So I'm presenting the psychological test results on her. You're not going to have this part of it for yours. And then I present, after I get all done presenting my evidence, then I present the conclusions. Then I present her um, and I talk about the response. This then is the response to the legal issues. Her ability to appreciate the charges against her. That is one of the things you need to take into account in a competency evaluation. Those of you who are reviewing or critiquing, this is one of the two charges, one of the two things that you could. There's multiple things. You only need to choose two of these. So what is her ability to appreciate the charges against her? My conclusion, despite her cognitive and emotional difficulties, she does have the ability to understand the charges being leveled against her. Second is appreciate the range of possible penalties to which may be imposed against her. That again is another part of competency. Yes, she is able. She stated that she could go to jail. She understands that she could be fined money, placed on probation, forced to leave her mother's home, all the different possible things. So she does understand that. Does she understand the legal process? The answer is yes, she does. She understands the role of the judge. She understands her prosecuting attorney. She understands The jury consisted of regular people who would determine if she was guilty or not. Does she understand her legal rights? Okay, so when she asks about her legal rights, she understands what they are. Can she cooperate with her defense attorney? Yeah, and then is she able to manifest appropriate courtroom behavior? These are the specific issues that need to be addressed in a competency evaluation. Ability to appreciate the charges, um, ability to appreciate the range of possible penalties, ability to understand the legal process, ability to understand her legal rights, ability to cooperate with her defense attorney, ability to make appropriate and manifest appropriate courtroom behavior. Um, don't think that yours needs to be this complex. So for those of you doing and I've said that multiple times, I know, because students freak out whenever I show them these type of things. Many students freak out, say, oh my God, I can't do that. Of course you can't. You're not there yet. You will, many of you will be here, but you're not here yet. Those of you who want to do forensic work, you will be here eventually, but don't think that you need to be here yet. Um, so, um, trying to say, so for those of you critiquing, pick two of these. Pick two of these to critique the individuals on. Those of you who are looking at John DuPont, you need to address these issues here or your evaluation is not complete. And I'm leaving this here for right now so that you can pause the video, write this down, examine it. And again, part of the reason, there's some spelling errors here because when I did the spell check, it went through and change some things. But these are the things that you need to look at. Okay, I'm going to stop here. This is what I wanted to share with you. This gives you enough with what is in the book, with what is in the book that you're looking at. This gives you enough that you should be able to do a decent job presenting next week, a decent job critiquing next week. And those of you who have to write up your reports, you now know how a report should look. This is how I don't have it here. I did erased it, but go back and take a look at my whiteboard. That's how your write-up should look. Any questions? I know I have somebody who is here, but are there any questions about this? Comments? Okay. Kind of a bit nerving talking to a big blue eye in front of me, or it's white eye. I don't know. The camera thing is there. Okay. Well, I look forward to seeing you on either Friday or Monday. Those of you who are doing this, if you have any questions, I'll be happy to address your questions in class after the presentations are done, but I'm not going to lecture on this in class since I've done it here. Have a great rest of your week, and I will see you on Friday, Monday, Friday.